aqui. Okay, welcome back. Now we're going to start a new panel focused on the International Law Commission. And first we will have Mrs. Luisa Pereira from the Federal University of Rio Grande do Sul, who will present a paper. And I had, my lucky guy, to have I think on first hand, I don't know. At least from this, from the perspective of this audience, the paper. A paper called The Work of the International Law Commission, the ILC, in the Eyes of the IOC, Mirror or Looking Glass. And after Mrs. Pereira, we will have Professor Lucas Carlos Lima with the topic, the role of regionalism in recent ILC projects. So first, Mrs. Pereira, you have the floor.
Thank you so much, Professor Galindo. Thanks again. I've already given all my many thanks before, but anyway, thank you so much, Professor Lucas Lima, for inviting me and having me here. It's a joy to be at UFMG and to speak to you about the International Law Commission, a dear topic of interest, something I've always been kind of fascinated by. I think international lawyers tend to look to the ICJ and the ILC a lot, and I'm definitely no exception to this. So I'll tell you a little bit about the story of how this paper came about. So my presentation is based on something I've written that happened to be the first thing I ever presented during my PhD. So I was in the first year of my PhD, and I applied for a conference in Manchester that was about the role of international organizations in the making of customary international law. And I applied with an abstract blindly, so I got the International Law Reporter email, and I saw it's kind of related to my PhD. Wrote an abstract, and it got accepted. And I was very fortunate, and I felt very excited, so I went on to research the topic. At the time, the International Law Commission was still working on their customary international law project at the time. So it was still an ongoing project, and what I didn't quite know, I don't think, from the call, was that it was part of this series of lectures or conferences that were being organized under kind of the auspices of Michael Wood, who was the special rapporteur. So he would go to certain institutions, universities, and he would get feedback on the project. And Jean d'Aspremont and Soufiane Droubi, who's actually Brazilian, who was there visiting, they organized this conference kind of with the idea of bringing Michael Wood there to hear about some things that maybe he thought were interesting or important regarding the paper, or rather the ILC work at the time. And it so happened that my first ever PhD conference was criticizing and talking about the project of an ILC member in the same panel as him. So that was terrifying. And today I have the pleasure to be again next to an ILC member presenting this, so it feels kind of full circle. But it is the second time in which I've presented this. Since then, the ILC has concluded its work on customs, so they have a series of conclusions and commentary. So my paper is going to be organized, or rather my presentation is going to be organized in kind of two parts. The first one where I tell you the approach that I had at the time before the conclusions came about, and what ended up being in the conclusions in the end, and how I personally feel about this, personally, having written about it at the time. So one of the topics that was before the Commission related to the identification of customer international law. First of all, that was a project that was proposed to the Commission at first as formation and evidence of customer international law. And that it then, right soon after it started being discussed, it became the identification of customary international law. So that already shows some of the cracks, I think, in the original project. So they went from formation and evidence to identification as an attempt to bypass some of the difficulties that custom has as a whole, right? For all of the international lawyers, anyone that works with sources, Lucas writes about this extensively. We're all fascinated by custom, and it's also a riddle for us because it's so complex. There's so many different theoretical views on the subject. And I believe one of the projects behind the project at the ILC on custom was to kind of settle some of these debates and bring forth a very pragmatic and some would say more or less conservative view on the topic of custom. But one of the issues that the Commission was having trouble with, if I can use that term, was what to do with their own materials. So on one hand, the Commission had a place for different aspects of customer international law, how to identify it, but how to talk about itself in its own work. So how to mirror itself in its own output. And that, I thought, would create, and did create, a lot of interesting debates within the Commission. And this is what my specific paper was about. So it's about a very discrete aspect of the Customary International Law project. So more specifically, the role of the Commission's own work in the formation/identification of customer international law. And I believe that even though it seems like a very narrow topic at first glance, it does unravel some of the larger issues within the project as a whole, and in the Commission's view of itself as well, which I find an interesting point of to be analyzed. So the ILC ended up dealing with its own work in this way in the Customary International Law project. And I will describe then the kind of debate around it and what ended up happening with the ILC's own work in the conclusions and commentary to in the identification of customary international law project. So they started this work on the subject in 2014. As I said, it was originally called Formation and Evidence and then went on to become Identification. The special rapporteur at the time was Sir Michael Wood. He produced until 2017, which was when I presented the first version of this paper, a series of reports, and the work was finalized then in 2018. And what we have now as the draft conclusions on the identification of customary international law that I'm sure that you're all familiar with. The goal, according to the conclusions themselves, was to offer practical guidance on how the existence of rules of customary international law and their content are to be determined, and it specifically mentions the need to preserve the credibility of determinations of customary international law as well as customary international law itself. So this very kind of role of teaching perhaps national jurisdictions in particular, national judges, how to identify custom in practice. And they had this specific emphasis on national courts according to the project itself. So the conclusions are 16 conclusions divided into 7 parts. And the part that I will be focusing on is called Certain Categories of Materials that are Frequently Invoked in the Identification of Custom. The IOC then enumerates in this part 5 of the conclusions and commentary that the materials that they will end up looking at are treaties, resolutions of international organizations, decisions of courts, and teachings of publicists. So anyone that is familiar with the ILC's work, and like I said, how much we care about it as international lawyers, will know that when we talk about custom, we imagine, or at least we know to some degree, that the ILC does play some kind of role in this murky phenomena that is the formation, or according to the ILC, the identification of customary international law. And at the time that I wrote this contribution, I thought the ILC could engage with its own work in 3 ways. So I knew that they were having, again, trouble in dealing with it. This is something that is apparent from the discussions themselves. So if you go on the records, you will see that different members of the commission had very different stances on how we should deal with it. It was something that Michael Wood himself was writing a lot about in his private capacity. So he would go to conferences and usually talk about it under the auspices of the teachings category about the work of the ILC and how the ILC was having to grapple with it. So at the time that I presented this, so before the coming about of the actual conclusions, I envisaged 3 ways in which I thought the ILC could deal with it, with its own work, to more or less, or in degrees that I classified as more or less desirable, perhaps. So the first possibility that I envisaged, which was pretty much from what I gathered how Michael Wood was personally positioning himself, was that the ILC would do the done thing. So if you open a textbook on sources of international law in the teachings part, they will usually classify ILC output under teachings. And that was the position that Michael Wood was taking in a lot of his work that he was writing as a scholar. So I positioned myself at the time against this particular take for a few reasons that I talk about in the paper. One of them is that I believe if we read closely the travaux of the Advisory Committee of Jurists that has made up the teachings of the most highly qualified publicists of the various nations provision in Article 38, 1D of the ICJ statute, that teachings were very much seen as an expression of scholarly work, and that I felt the work of the ILC, specifically identification, codification and progressive development of international law, fell out of the scope of this teachings category. So if we were going to take a more literal approach to the term teachings, I believe it would perhaps not be best advised for us to just lump the ILC work alongside with teachings. So that was one of the reasons, maybe the more acceptable reason why I thought it wasn't the right fit. And the second reason that was more ambitious perhaps to propose to Michael Wood at that time was that I felt the role of the ILC in particular instances in the formation, perhaps development of customary international law rules, in practice was greater than that of regular teaching. So if we're going to look at how international law works in practice, if we take the view that I perhaps take, that customary international law is better understood as a something that develops over time through the interaction of several actors over that time. So if we take more the kind of Jennings-Crawford school of customary international law, we would have classifying the ILC's own work under teachings would also downplay it in a way that would be, that would perhaps compromise the role of the ILC's work on custom that was to help national judges specifically, or people who weren't familiarized with the actual work of custom in practice. So downplaying its own role would actually have a detrimental effect on what it is trying to do. So it's proposing itself to do one thing, and it classifying its own work as mere quote-unquote teachings would be inaccurate in that sense as well. So another reason, or another possibility I envisaged for the ILC to deal with this issue, or to the issue of how it would look, or talk about how it looked at itself, would be to include it as its own separate category under Part 5 of the conclusions. So under the materials aspect of the conclusions, So alongside all of the previous ones that I mentioned, so decisions, output from international organizations, etc., it would have its own separate category under those auspices. So it would list itself as a specific category. Though I thought that would be perhaps the most accurate approach, because I do think that the ILC has a very sui generis classification or a role in certain contexts. So I think that for the purposes of accuracy, perhaps it would be the best move for it to be its own category within the materials part of the conclusions. I also knew that that was an unlikely possibility for the Commission, because the Commission itself, or part of the problem the Commission was having, was that it felt it was being overly congratulatory of itself. So it felt that it was boasting itself too much, that it couldn't talk about itself in those high terms, that it couldn't put itself perhaps in the same level as especially the work of states within international organizations, for example. So a mix of state deference or deference to states, state clients on one hand, and on the other hand, this idea that it couldn't portray, it didn't want to portray itself as overly important. So that was definitely a concern amongst members. So I knew that that second possibility, even though I felt like it would be perhaps the most scientifically accurate, it was unlikely to happen at the end. And then I also had a third, more what I thought was a more pragmatic suggestions, but that I also felt was relatively accurate in terms of what the conclusions were saying they were trying to do, was to include itself as a subcategory within the kind of decisions, the court decisions category. So it would, of course, a different kind of output, but with the same level of, or that would require national jurisdictions especially to look at it with the same degree of engagement that they would, for example, an ICJ decision, etc. So that was a third pragmatic, but I still felt accurate possibility for the ILC to engage with its own work in a way that balanced this issue of it being over self-congratulatory on one hand, but still maintain the accuracy aspect, scientific accuracy on the other. So I very much patted myself on the back for this pragmatic suggestion that I made in the first year of my PhD. And I moved on with my life. I continued writing, doing my own thing, writing about obituaries, so definitely not related to the ILC. Well, somewhat, because a lot of the people that were memorialized were people that were ILC members as well, but in any event. And then in 2018, the final conclusions and commentary come out. And I was fascinated to see the way in which the ILC actually ended up dealing with it. So I didn't give you spoilers before, but basically what they did was they included mention of their own work only in the introduction to the commentary of part 5, which is certain materials. And they did so in the following terms. So I'll read it out to you. So the Commission decided not to include, at this stage, a separate conclusion in the output of the International Law Commission. Such output does, however, merit special consideration in the present context. So, great, merits special consideration. As has been recognized by the ICJ and other courts and tribunals, a determination by the Commission affirming the existence and content of a customary rule may have particular value. So again, as may a conclusion by it that no such rule exists. This flows from the Commission's unique mandate from states. So that's where the kind of issue starts. Unique mandate from states. So again, not itself, but states, not its members, but states. To promote the progressive development of international law and its codification, the thoroughness of its procedures, including the consideration of extensive surveys of state practice, and its close relationship with states as a subsidiary organ of the General Assembly, including receiving oral and written comments as it proceeds with its work. So states again. The weight to be given to the Commission's determination depends, however, on various factors, including sources relied upon by the Commission, the state reached in its work, and, above all, upon state's reception of its output. So that was an interesting way of going about the whole conundrum. So I thought that the approach of the Commission was interesting for at least 3 reasons. So the first reason is that it didn't take the easy road. So it didn't go the traditional route of most sources' work that looks at something that is authoritative and can't explain why, and therefore fits it, wedges it into the teachings category. So they didn't end up doing that, which is what I at the time suspected might happen especially because of Michael Wood's personal work on the subject that he was presenting in several conferences at the time. So they didn't take that route, and I thought that was good for all the reasons that I mentioned in the paper. If you want to go into the debate at the Advisory Committee of Jurists, you can do so at your own peril. The second thing I thought was interesting about the approach was that it did acknowledge some role for its output. As it says, it merits special consideration and it may have particular value. So to some extent, it cracks open the otherwise conservative approach it took on customary international law, enshrining the 2-element approach and not really providing for a lot of leg room when it comes to that. So that was a crack in an otherwise quite conservative project, in my view. However, it was interesting that it chose to do so, always hammering on, if I pardon my French, by attaching itself to the special role given or that it has in relation to states. So it brings up states on several occasions in the commentary itself. So of course, I did have an issue with the fact that it's hidden in the commentary. So if it does purport itself to be a guide for national jurisdictions, judges that are trying to identify customary international law, I do think it's a problem that it's not listed in the actual conclusions themselves, that a judge would have to read in detail part 3 of the commentary of part 5 to be able to find any mention of the ILC's work. However, I believe that they did do, in my personal view, a good job against going into through the teachings categorization that I find is maybe a bit lazy. I did think that it was great that they did affirm some role to their work. However, they did do this overtly addressing the state issue. So they did attach their preponderance or their importance to the role of states, which is perhaps not the way or not the real reason why I think, if we look at the practice of the ILC, is the reason why they end up becoming so important. And many people have written about this. Fernando Borgin has an article about it, which I find really helpful, but that they acquire a certain legal status that is sui generis, perhaps more akin to ICJ decisions than anything else. And that is sort of the end to my story, so it's not really very climactic. But I do think that it is an important topic. It's not just a topic that has died with the Customary International Law project as a whole, especially because the Commission currently is discussing the subsidiary means for the determination of rules of international law, where both the teachings point and the ILC output point are going to become, again, a point of contention. So there has been some mentioning, so I haven't gone deep into the discussions themselves, but I did read briefly yesterday, actually, that Special Rapporteur Jallow has already has pronounced himself about the intention to engage with the operation of expert bodies. So it does hint at the idea that they're going to have to re-engage with the work of the ILC itself. And I am curious to see how the ILC will engage with its own work in this particular instance. If it's going to go back to that teachings approach, if it's going to try to do something else, if it's going to tackle perhaps more head-on the self-congratulatory versus accuracy dichotomy. But I will definitely be on the lookout for that. So thank you very much.
Thank you very much, Luisa. Now I give the floor to Professor Lucas Carlos Lima. Go ahead.
Thank you very much, Professor Galindo. Good evening, good afternoon, good evening, everyone. I will not thank anyone. I would just thank you all for being here until the end of our session. For me, it's a great pleasure to hold this event here with all these masters and have our students at UFMG, but also students that came from all the universities to learn from Professor Klabers, Professor Galindo, Professor Luisa, Professor Morosini, and Professor Micheli. For me, it's a great pleasure, and I'm very, very happy that you stayed with us to the end. I'm also talking about the International Law Commission, and especially the role that the International Law Commission has attributed to regionalism in some of its recent works, and also the work that Luisa has just mentioned, the work on international customary identification of customary rules of international law. As you all know, the International Law Commission has reserved conclusion 16 to particular rules of international law. They're comprising some of the regional rules from Latin American, African, and also bilateral rules. So there is some cautious approach to the notion in that work. But also the question of regionalism has appeared in different projects. Actually, it's a node topic of the ILC. And since this is our ongoing research, any kind of reaction on feedback, I'll be more than welcome to discuss in these questions and also after. The International Law Commission in 2006, the Koskiniemi report on fragmentation of international law, has framed regionalism in 3 ways. First, identification of regionalism as a set of approaches or methods to examine international law, something more related to sociological or anthropological approach to the law. Regionalism as a technique for developing international law, so pretty much in what we're examining here, how to create regional rules of international law, and also regionalism as a search for geographical exception, the dangerous part of regionalism that perhaps threats the universal project of international law. And this has to do with the mandate of International Law Commission. The late Judge James Crawford, and former president of International Law Commission, once described the work of the International Law Commission as a work of resolute universalism, which has been followed by the Commission ever since the beginning, and this is Judge Crawford's words, so much so that the issue of regionalism is mostly not raised in the Commission's texts. It has no purchase such an idea. And we could identify that in these recent works on the identification of customary international law, on Hughes-Coggins rules, and also in the unfinished works on principles of international law. And I was wondering, while Luisa was talking, if this is going to appear in the teachings work also. So my focus here is twofold. One, I would like to examine the extent to which the ILC uses the practice of regional practice to formulate general rules of identification of international law, and how the ILC accommodates regional rules in these 3 projects, to what extent that it accepts that there can be a regional Hughes-Coggins, regional principles, or regional customary international law. And I will pay special attention to the practice of the Inter-American Court of Human Rights, that perhaps is a practice that can offer us some elements to reflect upon. So the work of International Law Commission on the customary international law. Again, one conclusion, admitting the possibility, the International Law Commission used a lot the case law of the Inter-American Court of Human Rights to confirm its own findings on the methods of identification. The International Law Commission said, well, the Inter-American Court identifies customary international law in the same way that we are saying here that is the right way to identify such rules, which if we examine the practice of the Inter-American Court of Human Rights, we can gather a different idea. There is no examen of practice or opinio juris at all. It's just an exercise of assertion on repetition of previous case law. The reference to practice is quite rare in the case law of the Inter-American Court of Human Rights, and it mainly serves to confirm the findings and interpretation of the one court. So this is a first use of regionalism, the regional practice, but to a certain extent, in the project, in the conclusion 16th, the court said, well, there are rules of customary international law, but they are more difficult to find. You have to, the criteria for identifying them is stricter because you need the consent of all states involved. So, to a certain extent, this is repetition of old case law of the ICJ, but to a certain extent, creating a great difficulty to identify such rules. One can read a regional reaction to that, and perhaps I'm being too risky here because the member of the Inter-American Juridical Committee that launched this idea is Professor Jorge Galindo. But apparently one can read our regional committee of the Organization of American States a little bit unsatisfied with the work of the ILC, and then it started to examine how in the American continent do we examine an identification of regional rules, which are these regional rules, and then consulted states specifically on these topics, something that the ILC did only quite superficially. So again, a movement and some reaction. Let's see if there are some rules that we consider important to a regional level, and the work of the ILC, in my opinion, was quite rapid, not to say negligent, to this kind of rules. Peremptory rules of international law, jus cogens, the work ended in 2022. The ILC again went to the resolute universalism. When the discussion arises about there are rules of regional jus cogens, the special rapporteur and some members said, let's not put this in the mandate, let's not exclude the possibility of such rules, but not elaborate on them, let's not complicate the project, let's keep our traditional approach, our traditional, and not create so many problems. If one reads the commentaries to the project, there is the possibility, well, norms of purely bilateral or regional nature are also excluded from the scope of this work. Again, perhaps there are, but we are not dealing with that. Let's keep with the resolute universalism. But there's a problem. The Inter-American Court of Human Rights identified many rules that has the jus cogens character that have no impact in the universal level. For instance, the non-refoulement, the non-discrimination rule, and quite recently, last Monday, there is this interesting case, La Oroya versus Peru, where the court said, well, the international protection of the environment requires progressive recognition of the prohibition of such conduct as an imperative role of jus cogens. Again, something that perhaps is regional, but there is no universal correspondence. Again, the ILC not ignore, but did not pay or miss the opportunity to elaborate, to discuss, and to give some reflections on what is the state of the discussion of this kind of rules. Last work, general principles. Again, when the mandate came, the special rapporteur said, I'm quite interested in identifying regional principles of international law. The work went on, and the regional part of the principles disappeared. The general principles, according to the conclusion 2 of the last document adopted last November 2023, there are two kinds of general principles, derived from national legal systems and formed within international legal system. In the commentaries, again, the issue appeared. There is no prejudice of the question of existence of other regional principles. Again, the ILC skirted the possibility of dealing with these topics, exploring these ideas, and we can say that, again, the inter-American practice has some possibilities. The pro persona principle, to start with, the uti possidetis iuris, and the Brazilian uti possidetis de facto. So we have some possibilities here that ILC seem not interested in exploring or at least discuss. My conclusions, because this is an ongoing project and discussion. In these three projects, the approach to regionalism was quite insufficient, in my opinion, and of course, to some extent, negligent. A missed opportunity to offer some guidance, and again, to discuss, at least discuss the extent to these rules can impact international law. The work of the Inter-American Juridical Committee, in this sense, seems much more interesting that now it was finished last week on Panama, apparently, if I'm not wrong. On the one hand, one cannot be very surprised, not even disappointed, if the International Law Commission for not taking regionalism so seriously into consideration. It's according to its mandate, also to a greater extent to its method of work, so let's not threat the universalist project in times of contestation and etc. But at the same time, one remains with the impression that the International Law Commission is not only concerned with the international side of story, neglecting this relevant practice. It uses this kind of practice to confirm its universalist project. One can be left with the impression that putting too much emphasis on regionalism could be a threat, or even a form of exceptionalism that was already envisaged by Koskaniemi, a form of exceptionalism from the universal rules identified or progressively developed by the Commission. So better not to put many ideas on states, actors or on state members, not give many ideas to develop international law. Let's keep with the universal project. One cannot also ignore the fact that states and some courts are not interested in this notion. Also, the Inter-American Court of Human Rights that only used the notion once to say that there is no such universal regional rule in relation to asylum, paying special attention to the practice to the US. So at the same time, yes, the International Law Commission is not paying so much attention, but on the other side, only some organs. I would say that the Inter-American Juridical Committee seems to be an exception, but the Inter-American Court of Human Rights is not interested at all in creating this kind of threat to universalism. As a matter of fact, the Inter-American Court is one of the courts that embrace universalists the most. So, be that as it may, it seems that the next chapters of this story tend to illuminate perhaps this tension already envisaged by the ILC in 2006 between the regional and the universal side of international law, especially in light of these novel forms of practice and instruments as adopted by some groups of states to advance shared values. The question that I keep in my mind during this research perhaps could be framed as who is afraid of regionalism in the formation of international law, but perhaps it could be better framed as who is really interested in regionalism in the formation of international law. Thank you very much.
Thank you very much, Lucas. So we'll open the floor for questions, observations. Professor.
Let me just cumprimentar o professor Hermes Guerreiro, diretor da nossa faculdade, que está lá ao fundo. Obrigado pela sua presença, professor.
Jan, just before you speak, because I would like to pose you a question related especially to what Lucas just said. Okay, so you're gonna. I mean, historically, especially here in the American continent, and I would add also in the African continent. I mean, international organizations, I mean, they were historically involved with regional norms. I wouldn't say necessarily customary norms, but I would say treaty norms and also principles of international law applicable in regional scenarios. How do we envisage the role of international organizations nowadays on this? Because I would, if you, maybe some examples could be provided, like for example, the OAS is historically known as an institution that fostered the right to a democratic regime in the continent, and also is very related to the development of rules on the use of force and the peaceful settlement of disputes in the continent. And maybe in the African continent we could add also other examples. So just you could ask your question, but maybe you could also provide some comments on this. Do you like the mic?
Thank you very much, Professor Galindo. That's an unexpected pleasure. Jesus. I think regional international organizations have been very instrumental when it comes to formulating substantive rules of international law. There is sometimes heard a call that experiences of regional organizations, especially from underrepresented regions, the Asia Pacific, for instance, should be taken into account when talking about things like organizationhood. I think the very definition of international organizations should take the Pacific Island Forum into account. I'm not convinced by that, partly because I'm not convinced we have any rules on organizationhood to begin with. But substantively, yes, sure, you're absolutely right, I think. But my question was a different one. See, I do this very smoothly. Already in 1975, I think, Sir Ian Sinclair wrote a piece rather critical of the ILC, invoking the poet Wordsworth, who had written the line, "a fen of stagnant waters," and he labeled the ILC as a fen of stagnant waters. So basically, water that doesn't move and just attracts mosquitoes, which you then need repellents for. The baby version, yep. I think that is caused by the circumstance that by the mid-70s, all the codification projects that it could have done were pretty much concluded. Like the first round of the law of the sea, law of treaties, diplomatic relations, consular relations. And what it has been doing afterwards, after 1975, has not been particularly successful. And I think partly because there was little custom left to codify. And progressive development has taken place elsewhere. The International Criminal Court Statute in Rome, UNCLOS in Kingston, you name it. All the big treaties of the last 40, 50 years have been concluded outside the ILC. So, I'm guessing George will disagree, but wouldn't it be time to just get rid of it?
All right. Okay. Other question? Maybe you could make a first round. You want the mic? Maybe it's better.
So my question goes specifically to you, Professor Lucas. You talked about how can we see regionalism on the ILC's work. My question would be maybe the opposite direction. How can we see then the impact of the ILC's work in regionalism? Does it weaken new regionalistic claims the more it ignores its existence?
Maybe a third one. Third question.
Front row.
Okay. A third and a fourth question.
So my question goes to Professor Luisa Leon. I thought this really interesting, the fact that you mentioned that the ILC's output is not perfectly described as a teaching of a publicist. And I agree with you. I think it's rather an incorrect or inadequate definition. But on the other hand, I think that sometimes the ILC has a certain circulatory system of its own, in the sense that many of the projects of previous projects of the ILC were used as the basis for subsequent projects and were sometimes even mirrored one in another. We can think of, for instance, the articles on the responsibility of states and the articles on the responsibility of IOs. So it was mostly an effort of finding the differences rather than the similarities. So I thought in asking you, how about this? If the IOC is not to consider its own output, its own work, as a source or a sort of source of international law, how it can build upon its own heritage of material? If I made myself clear, but this is my question. Thank you.
My question relates also to the question of the practice of regional organizations, because as Professor Luisa mentioned on the report about the identification of customary international law, we have the mention of resolutions of international organizations. Again, in the reports, coming out about the subsidiary means, but without a different clear distinction between the practice and the resolutions of universal organizations and regional organizations. So my question would be if this regional acts and regional resolutions can also be used for the identification of universal international law, or they will be of specific use from the identification of regional rules.
Maybe Luisa first?
Yeah, yes, of
Okay, Luisa, go ahead.
Thank you so much for these questions and for giving me the opportunity to talk about the ILC again, because it's what I like. So I think that also answers my Jan's provocation that wasn't directed at me, but I'm going to react to it anyway, about getting rid of the ILC. So I recently read an article that we were just discussing yesterday that came out in the Leiden Journal, written by Carrie von Dowen, where she talks about how this idea that the ILC is a failure has existed since its inception. And she does this kind of historical tour of the discussions amongst the people who founded the ILC, the 17 men at Lake Success. It sounds very fancy. And the idea that the ILC is always in this constant struggle between self-congratulation on one hand, self-reference on the other, which kind of goes to your question, and this idea that it has to die, it does nothing. And she kind of does or makes an effort of digging through these archives and debates over time to show in her argument that, that I'm of course paraphrasing, that it's always been the case. So since the inception, it's always been a struggle of asserting itself, but also not asserting itself too much. I think the ILC has this maybe particular characteristic where it both considers itself too important and not important enough, and it maybe something that it should take to therapy if it was a person. But this idea that it's both very self-important, or that it takes on these big debates of international law like custom and says, I'm going to settle it. But then when it comes down to it, the results are more meh, or what has really been achieved, and then it goes back to scholars and international lawyers to discuss it again in fora like this. So I think there's an element of that, of its it being structurally inscribed, as she puts it, in the actual in the foundation of the institution itself, this kind of dichotomy between codification and progressive development, but also it's both, but it's neither. What does it actually do? And all of these tensions are actually there all the time, and that what it actually is, and this is my word, these are my words and not hers, or that the best way in which we can understand it is that it's a forum in which these things can be brought again and again for debate, and for us to have resource to the debates within that community, those debates trickling into academia, them also trickling up through the movement of commissioners themselves to the ICJ, for example. So maybe they have something that they've written in the context of the ILC, then they insert it into the ICJ, or etc. So that it's part of this bigger community of international lawyers having the same discussions over and over again, that it's a piece of that puzzle. I don't know if that answers the question, but then maybe it's stagnant on the surface, but that there are currents underneath that keep it moving and that give it a role within international law that we should look to. At least that's what I think. But then again, I am kind of obsessed with it, which, I have my own biases. Regarding the kind of circular motion between specifically the articles on state responsibility and Dario, I think that that's right, that there's an element of self-reference that's interesting and that we need to take into account. Again, like I said before, the movement between ICJ and ILC, other people have studied. Omri Sender has published on this as well, a lot of other people. But I think that it does play this role of circulating certain ideas within itself, but at the same time it has this difficult relationship with how it's going to deal with its own authority and its own work within that system. A lot of times I think it, maybe for fear of being self-congratulatory, maybe for fear of offending states and in a way removing its power by being too overt about the power that it thinks it has or that it actually has, it ends up taking this third stance, which is kind of a murky stance on its own work. I mean, I'm not sure what to make of it, but I think that that's a good point, that it does have this self-reference and this internal dynamics that is really important and that we should look at as scholars at least.
Professor Lucas.
Thank you very much. Let me start with Augusto. The impact of the IOC on regionalism, or at least on regional organs, I think that the impact is quite strong. If you look at the Inter-American Court of Human Rights, they pay a lot of attention to the works of the IOC. They always try to influence what is going on, crimes against humanity, the work on Jus Cogens. If you look to the timing of certain decisions, they are really paying attention what is going on in Geneva, and apparently they would like to influence the debate without success. But they are particularly aware what is going on in Geneva in San Jose. In the Inter-American Juridical Committee, I have the same impression. The work on regionalism dialogue directly with the work of ILC. Other projects also, they pay attention to the previous projects of the ILC, previous projects of codification. So I would say that at least from Latin American organs, there are some attention, at least in these two institutions, on what is going on in the main work of codification. And there are also some informal dialogues. There is every year the president of the Inter-American Juridical Committee, that is right now Professor Galindo, they go to Geneva. He's already there. They go to Geneva, present the work, try to establish some dialogue. So I think that there is some content, but perhaps Professor Galindo could tackle this question better. But my impression is that the ILC is quite influential in the region. There are some organs that are particularly prone to try to influence it, my impression from what I studied. Rafael, resolutions of international organizations, are they different for the formation of international law? I think that depends on context. I think that the general approach of that depends if this is a certain practice of states. This depends on if they name principles apply to America. The Declaration on Democratic Principles are specifically related to America. To the extent that they adhere to a universal practice, they are part of a general universalist customary international law, customary principles. To the extent that they have particularities and differences, they are creating something new. So I believe that the resolution of regional international organizations, especially the Organization of American States, can have a special role for identifying those rules. But I think that it depends on the context, the framing of the text, and other specific contexts. But if you consider the case of Bolivia, Chile, the ICJ was not so convinced that obligations could be created through the language of that specific number of resolutions invoked by Bolivia. So I think that, again, you have to look at them carefully to identify to a certain extent that they make some regional law emerge. Professor Klebers, do you still need the ILC? Well, right now there is no one really attacking it as the WTO, so we had a narrative in the panel before, but I think that, like the panel before, they showed us that we are probably going to create something similar to replace it, so perhaps it's better to keep it as it is rather than to create something new. That's my impression. And thank you, that's it.
Okay, maybe because my name was mentioned a couple of times, so, but I mean, regarding Luisa's presentation, I think it's quite interesting, this reading of the Customary International Law Project, and I mean the self-reference effort the IOC made. And I mean, speaking very frankly, I think that was a tactical move by the IOC. And I think there is a link with the question posed by Jan. I think there is a wonderful article written by Marty Koskiniemi, which is called International Legislators Today. I recommend you to read it, because it's, I mean, and it's wonderful the way he starts. It's a conversation with someone. He was asking for votes as a member of the IOC, and then, I mean, after becoming sincere during the conversation, I mean, the state representatives say, "Oh, get rid of this. The IOC is not useful at all," something like this. And this is this anecdote Marty tells is important to establish the importance of international legislators today, the importance of IOC today. I think it was a tactical move because, I mean, the IOC is trying to, I mean, to be in two worlds at the same time. I mean, it still tries to, I mean, to craft draft articles that will be future conventions, although I think almost those projects will fail. Being really honest. And on the other hand, the IOC is trying to think about a world where no new treaties will arise. So there is a recent article written by Georg Nolte, which was a member of the IOC, and now he's a judge at the ICJ. He speaks about a turn from codification to interpretation. And he says that it's important that the IOC positions itself in a world where interpretation is a very important tool. So you don't have new rules, but you have to interpret old rules. So I think the IOC, this is a tactical move. I mean, trying to be an important actor in terms of the interpretation of international law. The problem is that there is the IOC must evolve in terms of fostering its own legitimacy, and I think there is a big problem in terms of legitimacy of the works of the IOC, in terms of representativeness, geographical representativeness, but also in terms of gender representativeness. I'll just provide you an example of a dispute during last session, exactly on the topic of subsidiary means and in the definition of teaching, okay? Because in English there isn't a problem with the definition that is in the statute of the ICJ, the most qualified jurists. But there is a big problem in the Spanish version, for example. In the French, there is not, but indirectly there is, I don't know, in Arabic or in Russian or in Chinese. But in Spanish, there is a big problem because the translation of most qualified jurists is los más calificados juristas. So it's a gender-biased terminology. It's directed to men, to jurists who are men. And although many people don't see this as a problem, I remember that we had a hot discussion on this, on how to translate the term, and the final decision was to find a neutral term that could be translated easily without this bias in Spanish. I think, although it may sound a very tiny thing, but I think this is the kind of thing the IOC should be concerned with, about the legitimacy of its own work. And of course, I gave an example of gender-biased terminology, but there is also the problem of linguistic bias as well, starting from the fact that Portuguese, for example, or Dutch, are not official languages of the United Nations. We don't have any easy solution for this, but the point is that it's quite unsatisfactory the way the IOC deals with many issues. I mean, the best efforts they made was to publish bibliographies, multilingual bibliographies in Chinese, Arabic, but they are not used. People do not read in Arabic. I mean, special rapporteurs, or sometimes even members, for example, who use Arabic as their common or language. So this is a big problem, and this is a problem related to the mindset that the IOC has adopted for a very long time. I agree. I didn't read this article. I agree that in many senses the IOC is a failure. But we have to admit that international legal scholarship in many senses is also a failure. Sorry about being so honest, but I think this is the problem, because we need to be concerned about this, about the effects of what we produce. We have to reflect upon the fact that we are here thinking about international legal issues. So I think this is the kind of thing that we have to be critical. I mean, not only the IOC, but the international legal scholarship in general is a failure. So, other points? Any other? No? Please, go ahead. You want the microphone?
Thank you. My name is Daisy, and I like to listen to Professor Morosini about the importance of the mediation on international crises. But how they go out, I like to listen to Professor Lucas.
Okay. A question to you that I have to answer. Está aqui ainda. Okay. Professor Morosini, the question is actually for you. The role of mediation.
Mediation. Yes, you mentioned in your presentation.
Yeah. Yeah.
By the way, do you want to pose a question as well?
Yes, of course. You see, Professor Klaver, it's a free-for-all during questions. You have received one, Professor Morosini received others. So let me end this session. Thank you once again to our panelists. It was a pleasure to receive you here